today. First highly anticipated panel discussion of the day. The topic under the microscope is critical for every legal professional navigating the modern landscape. AI in legal practice, transforming research, compliance, and legal operations in the Indian context. And for this, I would like to call upon stage Jaya, Kathju, Associate Director Legal at Lilly. Let's have a huge round of applause, everyone, for Ms. Jaya with us. Our second panelist, Mr. Gaurav Sahay, founder and partner at Arthashastra Legal. Our third panelist, Priyesh Sharma, Assistant VP Legal at Knowledge Realty Trust. Our fourth panelist, Hena Datta, Head of Legal at Emmvee Group. Our fifth panelist and moderator of the session, Ms. Smitha Chandrashekar, Legal Director at Harman International. Let's have a huge round of applause, everyone, for all our panelists.
Hi, I'm Jaya Kathju. I work with Lilly. I manage the legal function at GCC India.
Good morning. I'm Gaurav Sahay, and I'm founder of Arthashastra Legal.
Hi, I'm Priyesh Sharma. I head the legal for South in KRT. Knowledge Realty Trust is the largest REIT of India, Blackstone and Sattva Group.
Hi, I'm Hena Datta. I head the legal and the compliance function at Emmvee Group, a solar and module manufacturing company.
Hi, I'm Smitha from Harman. JBL speakers, I think everybody knows. So I'm with the Global Ethics, Compliance and Privacy team. Been with Harman for more than 6 years now. Happy to moderate this panel, and wow, so many minds, thinking and staring at us. We'll try and do, a good job, hopefully. So with that, I think, in terms of setting the context, I'll just give you a couple of numbers in terms of statistics. The global compliance industry as a whole, right? I mean, everything put together in terms of market size, the platforms which kind of have evolved over a period of time and all of that. As of now, the industry is valued at about 10 billion, right? And of course, countries like US and a few countries in the Europe are in the forefront. India is not far behind, and in fact, Bangalore, as of today, in terms of supporting the compliance industry, GRC as a whole, it's valued at about $2 billion US. I mean, that's quite huge. And in the next 8 to 10 years, this is set to grow potentially and exponentially because of the demanding and rising needs in this area, right? So we're looking at figures of about $35 billion, by 2033 to 2035. That's the time frame that we're looking at. So I think that's mind-boggling. And the numbers, the reason why I mentioned this, to kind of begin this conversation is because that just shows how big this industry is going to go, the importance and things like that. So I just don't want to continue further and steal this show. Instead, I'll jump right on to the questions. Jaya, first question to you. Which legal tasks are best suited for AI and which still require human judgment? I think that's the basic that at least student community as such, would want to know. So if you can kind of take us through, it'll be good. Thank you.
Thank you, Smitha, for the question. The basic concept is that AI processes the information that is available, but strategy, risk assessment, and judgment should rest with human beings. For example, AI can increase the speed by preparing the first draft of a contract or reviewing a contract in terms of whether it deviates from the playbook or summarizing. But it cannot make negotiation strategies. For example, AI can tell you whether the indemnity is broader than what is suggested by the playbook, or whether the indemnity cap is higher than what is suggested by the playbook. But whether it is commercially worthwhile to accept such clauses or not should depend with a human.
Perfect. Thank you so much, Jaya, for that. Next, I'll move on to Priyesh. Since you're from the PE background, Priyesh, the question to you is, do PE and institutional investors, are they increasingly focused on speed and efficiency? That's one part. Second part is, do you see AI becoming a competitive differentiator in deal making, or could excessive reliance on technology create a new category of diligence and executing the tasks?
So honestly, Smitha, there is no yes or no to both the questions. So definitely today we are at a stage where if I say that we should not trust or use AI, that would be wrong. We need AI, we need these tools, software at a lot of stages. No, undoubtedly, it's very important when it comes to speed and efficiency. Like and PE, private equity or institutional investors, they run on speed and conviction. Speed and conviction both are equally important for them. When it comes to speed, definitely AI is something which is giving a wonderful solution. Like you can't imagine, like even if a team of 10 lawyers are sitting, they can't review 2,000 contracts overnight and give you red flags and solution, which AI is doing. So when it comes to speed and quick answers, AI is definitely there, which is giving, which is a big support and like something which is driving the institutional investors. But the thing is, at the same time, when we talk about conviction, I really don't think we are at that stage right now where AI is actually giving you that conviction or confidence. The problem, to my mind, it's not that, the risk is not that AI will give you wrong answers. Definitely it's going to give you good answers, better answers, fast answers. But the problem is the confidence which AI gives you, which encourages you or demotivates you from asking more questions. The confidence to trust AI completely and go completely by its judgment. As long as AI is an input to your diligence or judgment making, it's fine. But if you start using it as an output, there's the problem comes. So definitely, it's when it comes to speed, efficiency and all, this is a differentiator for institutional investors in private equity. But yeah, in terms of risk and all, something what we called like false comfort risk or checklist diligence kind of thing which is happening. So there's something where we need to put some restriction, as Mr. Bhasin rightly said, that technology has grown in a like devastating speed. So we need to put some checks, balances and all there. And yeah, it's at different levels, whether it's about the completeness of what AI is doing, or it's about bringing the human judgment at the right level, what Jaya very rightly said, that human judgment needs to be there when you think about the commercial aspects of indemnity, things like those. So, or reading behind the clauses. AI can do very well reading what is written over the clauses, but what is the intention behind the clauses, what's the commercial factor, what promoters were thinking, why government thinks like this, or if a regulator is tolerant, why it's tolerant, a lot of those factors. So to the second extent, yes, that risk is quite high. We need it, but we need to manage the risk. Or the simple thing is use it, but don't trust it.
Absolutely, thanks Priyesh. And again, just to kind of put things into perspective, right, from a practical standpoint, so just take our company, for example, right? We are required to comply with about 4,000 types of regulations in India. And rightly, like Mr. Bhasin said in his opening speech, it's just getting complicated because so many newer laws are coming and the compliances are increasing, right? Now just imagine if all of this had to be done manually. Thanks to all the GRC systems and this InfoSec team and it's a collective effort between various teams, right? It's not just legal and compliance taking care of everything on its own, right? There are functional heads who kind of have the functional knowledge, who kind of contribute towards all these things, and it's kind of a collective effort, right? So with the tools coming in, it's easier, A, to monitor, B, to kind of implement anything, C, it also reduces the reliance on external parties, right? Because till now, we were at the mercy of the external consultants. Whatever they advised, we kind of had to follow, right? Because they were the people on the ground and they were kind of advising us. Now, that's no longer the case because there are several different tools which are available. It's a consolidated, kind of a platform where the data from various functions are kind of pulled in along with the regulatory requirements. It kind of comes up with the red flag, which are the serious ones, which can wait, things like that. So in essence, I think these kind of platforms and technologies make our lives easier, but like you rightly said, Priyesh, I don't know, there's no right or wrong answer. So I think depending on your industry and depending on the complexities, you'll just have to weigh in for yourselves, right? So that was just my 2 cents worth of addition to what you said. Next, moving on, Gaurav, the next question to you. You come from a private practice background. So with the increasing adoption of LLMs and RAG systems, AI-powered legal search platforms, right? So from a law firm perspective, how do you think law firms should kind of, allocate responsibility specifically with respect to AI-generated outputs, right? And things like inaccuracies, hallucinations, and all of that. If you can touch upon that, I think that'll be beneficial to the audience.
Yeah, thanks, Smitha. I do not have the experience that Dr. Bhasin has, 63 years. That's not my age also. But I'm of at least that era where the matters would come and we would draft overnight and file writ petitions next day. And that speed would not be an excuse for verification of case laws, of grounds, and of other responsibilities that was bestowed as well as determined of a lawyer, right? I'm also now of a generation where the tools are very effective, but at the same time, the standards of professionalism as per the Advocates Act, that is verification, is not bereft of that. Irrespective the speed, irrespective of the results by the tools, the professional by no means, just by means of delegating whether to an associate of your office or whether to a tool, which is automated tool, does not take away the responsibility of professionalism or even the basic tenet of your profession, that is verification. If we go towards the in-house part, I think you would appreciate that is the standard operating systems, the accessibility, the tool, the dependability on those are very standard things of which we have to be very clear about. And just because the tool produces faster results does not mean that we do not verify whether the case law presented by the tool actually exists or not. Yes, the elder generation would always feel that we ran through libraries. If the library is on the palm of your hand, it's definitely a better way to say that your efficiencies should enhance and your verification skills should enhance. The skill set of using the tool should enhance. But at the same time, the very dependability on your professionalism or your even allocation of your delegation of your responsibility to even a live person or a tool does not take away your responsibility. That's.
Can you also touch a little bit about hallucinations?
So the thing is, definitely the AI tools are not perfect. It's at the very basic, it is still artificial. It's not the human intelligence. It depends on a lot of data that is there on Google. And just to give you a very fine example, obviously those days I'm talking of is early mid-2000s, when a play school where my daughter used to go, there they announced a holiday which the other parents objected, saying that that day is not the holiday. So the person who declared the holiday list, she just depended on a Google search, which projected that on that day was a particular event. So the school ended up declaring the holiday. So when we looked into it, obviously my reference point always was the High Court calendar, because that would be the most genuine part of the holiday list. Till date, it is my reference point is the High Court calendar. So you see, the thing is, so much of data is available which is unverified. It is, and especially we should appreciate that the intelligence, that the tool that we are depending on is artificial. It is depending on a lot of unverified data. So when we speak about hallucination from the I'll not go on the technical perspective of hallucination, but more on the practice perspective, is something that one is not bereft, as I'll reiterate, is of verification. That is your basic principle of your professionalism.
Smitha, I have a question for you, Gaurav. So with this AI speed and everything, is there any impact on the billable hours of lawyers? It's a very
no,
genuine question.
I must tell you, this happened actually with us. My senior associate is here. Yeah, she will be more adept in commenting on that question, maybe off the record here. But there's one client who came back to us and said, why do we need lawyers? I can draft an agreement in an AI tool. So obviously it was an existential threat for me, but then the fact is, we still said, please give us the draft that your AI tool has drafted. It was a 65-pager document of an IP assignment agreement, and when we meticulously went through that, the basic thing missing in the draft was what actually you are assigning in terms of IP. So you see, the thing is, when we talk of billable hours, yes, it is definitely increasing our churning out process, but it is also in a way artificially jacking up the client's expectation of inhumanly producing documents, which in a way is a risk factor for the client itself, because it is mostly unverified. Because at the end of the day, even my speed of drafting is enhanced by the tool, but at the end of the day, my vetting of the document will take time. So yes, in a day, if I say I would churn out around 3 documents by my own drafts, it might go to 4.5, 5. But that is with a very precautionary way of vetting the documents before it sends out.
I agree. I think human judgment is priceless.
Human judgment is.
Thank you so much, Gaurav. It was really good. Next, moving on, Hena, the question to you is, from a GC's perspective, right? We've just heard from Gaurav about the private practice perspective. So with boards increasingly asking questions on AI risk, transparency, and compliance, should a GC present a board-ready AI governance framework? And also, what are the non-negotiables for a GC, to institutionalize today?
Yeah, so as a GC, we have to ensure one thing is the AI governance is board visible. One. Secondly, it should be auditable by the board. Today, the shift in the trend, what we see is that board is not asking whether we use AI. They are asking whether the risk is covered by us. So, and today one of the agenda of the board when we are reporting is to track where all we are using the AIs, what all functions we use, because today many of the functions in the org has been using sales, the HR, the compliance function, the legal function, all of them try and use AI. So we generally have to map. How we do is, one, we have a AI policy in the system, not an IT policy only per se. Second, we document the systems, we document which AI system we use, org-wise, right? Thirdly, I can think of is where we document, as in what are the AI, like we prepare AI register where the number of systems and the categorization of the risk, as in the high and the medium and the lows are tracked. We also do the governance by ensuring that if AI is being used, where it is permitted, which are the areas it is not permitted, and where approval has to be taken even if it is being used. So that is another one. Another one is to ensure that what input is going in. Can we give this kind of data into a tool, right? Because it is learning and it might also give that output somewhere else. So what data is going in, what data is coming out of it, and whether the decision that is being taken is monitored. And human touch is a must. So the ownership is not only lying with the legal team, it includes the business, it includes the tech validation as well, apart from legal. So I think we must ensure that we have all this auditability, the traceability, the ownership, visibility to the board. Yeah.
Perfect. I think, very simple and practical and effective, Hena. Thanks for that. I think just also a couple of things that, AI kind of in terms of risks, right, which before I move on to Jaya, who would be talking about Gen AI risks, I just wanted to kind of let the audience know that it's as far as AI is concerned, there is always an interdependability and interplay between various other sections of law, right? Privacy is one of the biggest of them, because AI poses a serious privacy risk, right? And other than that, cybersecurity for sure, because and that's the reason why Hena specifically mentioned the tech team being involved in all of this, because that reliance is definitely required. And also back to basics, things like your Evidence Act, and whole bunch of other Indian regulations, right? I mean, you just have to make sure that whatever technology it is that you're using is kind of within the framework, right? So I think just those two couple of points which I thought was worth mentioning. So moving on, Jaya, the next question to you is in terms of Gen AI, if you can point out the biggest risks from a practical standpoint, and if you can also give a couple of examples, that'll be good.
So the biggest risk of Gen AI is passing on the output without human verification, without a human in loop. There have been cases of hallucinations, as we mentioned, where citations were cited which did not exist. And also an example could be where we had a clause that looked perfectly drafted by Gen AI, but then there was a carve-out which was not applicable to the legal context, to the business context. That is something only an experienced lawyer or a human can identify when looking at a clause. So it may look very easy to draft or very quick or very speedy, but you actually need to put in the effort to verify and keep a human in loop. And there have been directives for a human to be responsible and accountable for AI produced output. There has to be, because the company will still be responsible for whatever output Gen AI gives. Another is, like you mentioned, privacy and cyber security. So we are putting confidential information of the company or of the clients in the tools. So we need to have tools which have the guardrails in terms of confidentiality, in terms of use of data, in terms of data retention. So that is something we need to take care of. Thank you.
Perfect. Thank you, Jaya. And in real life, example, my daughter is a dancer. So apparently whatever competitions these days that, they organize, generally worldwide, apparently they are running checks on YouTube and various other databases to make sure that the choreography is original, right? Now, this is a work of Gen AI. And the risks here are obviously, is that material copyrighted? And if we are running this, kind of so-called search, like, is that violating anything? That God knows. Secondly, privacy risk is huge, right? Because those individuals, whoever have danced and, it's their images, it's their likeliness, so on and so forth, right? Which are potentially at risk, right? Just to make sure that the choreography is original, there may be several infringements which could occur potentially. Right? So that's how effective Gen AI is, but also at the same time, there is enough and more risk as well. To tackle these two, to bridge the gaps, I think human in the loop is still required. So with that, let's move on to the next question to Priyesh. Have you encountered any situation where over-reliance of automated reviews, data room analytics, or AI-assisted diligence resulted in issues surfacing during post-closing integration activities? And also, what lessons did those experiences offer?
So luckily, I have not seen so far where use of AI has resulted in a collapse of a deal. So that stage is yet to come, we'll see. But yeah, definitely overuse of AI or excessive reliance on AI, it just leads to post-closing surprises. A lot of things which you relied on pattern and algorithms and all, it will show its result and potential risk after the closing. That's for whether it's a minor thing or a bigger thing, it depends. But those things are very, very common. So for example, just before that, yeah. So as I was said earlier also, I think the two aspects where I think while AI is giving you speed and mainly speed, the main thing which is missing is the completeness and the human factor. So when we talk about completeness, the biggest, I think the disadvantage or limitation which AI-based diligences or use of AI for any other check is that it relies on the data provided to it. If your data room is like, if it has 2000 documents, it will summarize, say, check those 2000 documents, but there's a lot which goes beyond those 2000 documents. There's a way, like I still, I think I started my career when we used to actually go to the sites, on-sites, factories in like different parts of India to actually go and do diligence there. If it's a labor law thing, we used to sit with those like guys who are actually looking after the labor. We had a long checklist. We used to ask them questions. Just by ticking that you have this compliances and all is something which AI is doing. But sitting with those guys and actually understanding how labors are working, whether this condition is fulfilled, what's the reason behind it, why this strike is happening, those kind of diligences had its own merit. Like you'll know, like at the time of integration, post-closing and all, you'll know much more than what AI is doing in terms of like your checklist-based diligences. Similarly, when we talk about reading behind the clauses, what AI is doing in terms of diligences is it's reading the clauses, it's giving you a perfect summary. So if it gives you a summary that, okay, you are doing this transaction, control change is happening, this particular contract has change in control clause, it's clean, it's all green. It will give you a very comfort report that 10% of the contracts fall under this risk and all. But what goes into reality after closing, during the time of integration is, whether, even if that contract is passing the check of AI, whether that contract is actually going to survive the post-closing integration or not. So I've seen big contracts which pass the test of AI during diligences falling after the closing, when you realize that the only reason that contract was running was because of the promoter relationship. There was a lot behind the contract more than change in control or assignment clause. It was perfectly assignable. There was no restriction on change in control. But when the transition happened, management change, control change and all that control, that comfort went away, and very like within some time and all, your business started falling. So it's a very practical example which AI will not give you that result. Similarly, like to give you a bigger example, which I have not seen in AI time, but it's, I think 6-7 years back when I was in my law firm stint. And that time I realized that people had started using technology, not exactly what we are, advanced stage, what we are using right now, but that time also there was some bit of technology and all which was used for diligence and other drafting purposes. So that time I actually saw, like, when the entire business transfer deal, everything was over, like at the time of closing, which happened after 3 months of execution, when we went to sub-registrar office for registering the document, the sale date, we realized that there was a circular, it's a Telangana case, there was a circular government notification which actually said that this land is a government land and you can't alienate it. The entire transaction, business transfer of 500 crores, which was based on a factory situated on that land, it just collapsed. So just imagine if similar transaction is happening today and AI is doing that diligence. Like if you don't give them complete data and there's one notification existing somewhere in public domain, or even if you go back to Ranbaxy Daiichi case, the famous arbitration of all which is like a Bible for diligence. Like there's one paper which is kept somewhere in a room, somewhere in data room, which is not even directly referred and all. It's very difficult for AI to give you that particular thing on which the entire transaction is based. So yeah, definitely there are a lot of such examples, but let's see how it goes. Technology comes with its own disadvantages. So so I'll just quote. I think we were on the same panel sometime back, where somebody quoted that AI is like a very, very efficient first year or a fresher or a paralegal kind of person who will give you like efficient answers, very fancy, dressed up, he'll come to office nicely, everything will be fine. But don't be surprised if one day he'll just show up in a complete hungover stage and give you those results. So be prepared for it and use AI with that mentality.
Thank you so much, Priyesh. Well said. With that, I think we'll move on to Hena with a different and an interesting question. So, if an AI-assisted decision, right, whether in compliance, contracting, or whatever the case may be, is challenged before a regulator or a court, right, what would make that decision legally defensible? And also, what frameworks should in-house counsels implement today to withstand that kind of a scrutiny and situation?
Yeah, I think the first test which I'll put is whether I can explain it in front of a regulator or a court. Because the moment court asks how you have arrived at this, I should be able to give a reasoning to give the whether a human touch, because see today regulators are also checking whether there is a compliance or there is an officer who owns it. The accountability is very much important to present any data, because when we have a grievance officer or a compliance officer, the accountability of that person when we submit by his signature to any regulator or maybe in a court, right? So we always want to see that whatever data we are putting, the decisions, the submissions we are making in front of our regulators are having the basic test of this one. Second is, I think we as a company are regulated by MNRE, BIS, and I'm not sure if you know that recently the one ALMM, so Atmanirbhar India, and also the ALMM 2 was made mandatory, where the Indian solar module manufacturer must use the India manufacturer's solar PV cells, right? After which so many associations have filed a writ petition in the court, and when such writ petition are filed, and of course the high courts have given it back to the MNRE, saying that you must make a representation to the authority or your regulator, and they will. So, but once I put those orders and the petition, I cannot go into the granular details, but there was one point which was not mentioned in the order, but the AI gave me that point. But because I have read the order and I was checking whether, because even we were supposed to make such petition through an association, so it gave up. And when I said that, no, this point, why did you say this point is not mentioned in the petition? Oh, yes, you are right. They told, yes, you are rightly figured out that it is not mentioned, it's my mistake, sorry. So, so though we have a licensed version, I'm not using a free version at all, but I have a licensed version, such I have got in my experience itself from my system, even if in license. So I think the basic which all of us agree is that human touch and verification and accountability, traceability, and where we can get the AI used, and where we cannot use, is something we will want to continue, monitoring. Yeah.
Thank you so much, Hena. That was like really helpful. Moving on, Gaurav, last question to you. Cross-border, right? I mean, what technical and contractual safeguards should be implemented when privileged or sensitive confidential information is processed through third-party AI platforms, right? Especially for models which are hosted outside of India.
So, the moment the models that are hosted outside India, the complexity of jurisdictions arises here. So, the traceability and in the hands of the processor, these are important determinants that are important to see where the jurisdiction lies. Now, with respect to with respect to the complexity of the confidentiality or the commercial aspects of a particular contract, now the DPDPA as well as the other regulations by the Government of India restricts very sensitive data movement outside the country. However, there are certain safeguards as well with respect to anonymizations as well as pseudonymizations of confidential data or personally identifiable data, which actually moves outside the country. The other good part of it is the laws that are being promulgated, or we are moving out of the biblical aspect of law, wherein the people who understand technology are, in a way, are the people who are in a way making the rules and regulations. Because by the time the legislature would understand the complexity of technology, the lion, and they would catch the tail of the lion had already escaped by that time. So in those aspects, I'll say we are more in synchronization with the international laws. Second, we are understanding the complexity of jurisdiction here, and also the very fact that the data could be retrieved. Those aspects of retrieval of data is something that needs to be really looked into. Because at the time, though you see the GDPR says 72 hours within which the data has been, you get to know about the data breach incident, you have to report it to the authorities. As per the American rules, it is depending on the severity, 24 hours to 72 hours. And as per the Computer Emergency Response Team of India, it's 6 hours. So somewhere we understand our role in the global aspect, and where India is still a service industry, right? So therefore the rules on us is even stronger and sometimes more, I'll say if other countries are saying up to 72 hours, and here we say 6 hours. So the severity upon ourselves is humongous. And that is where I think, but then the real aspect, as what Dr. Bhasin also pointed out, was something very real. We are all talking of something very superficial at the time, right? But on the real aspect on ground, what is the result is something that we are yet to achieve. Because I may expedite some things, I may look at certain things from a speed perspective or efficiency perspective. But on ground, the result, whether the efficiency or the desired results are being produced on grounds, those are, and that is exactly what Priyesh also said, that unless and until you be there and you do the work, those are the things that otherwise it's all on the superficial level at the moment.
Thank you so much, Gaurav. So I think with that, we kind of end the session here. Thank you so much, each and every panelist. One second. Yeah. No, I will open it up for questions. So just give me a minute. So thank you so much, each and every panelist. I think you guys really did a wonderful job. And I don't know about audience, but I definitely, thoroughly enjoyed it, and, great takeaways from this session. With that, I think I'll turn it over to the audience for a couple of questions, if you may have. Yes, sir, please go ahead.
It's not a question, but it's an observation of something which happened about 2 weeks ago, when the Supreme Court quashed, a Punjab and Haryana High Court order. The reason was, the judgment said, the Supreme Court called hallucinated facts. The court used that phrase, hallucinated, therefore giving it a legal sanctity, which in any case now is in their draft rules also. Meaning that the High Court either invented something or relied on AI output that invented something. He says, we don't know which, but the word is now a Supreme Court order. So I asked, a sitting judge of the Supreme Court, I say, how do you explain this, why is it happening? He said, and that connects with what I was referring to earlier, pendency of the cases, and how AI, is trying to complicate that issue. It says, what is happening is that some courts are under extraordinary pressure. That is the case pendency, understaffing, judges who are managing hundreds of files simultaneously. AI tools are being used as a shortcut by some, not all judicial officers, and perhaps even their clerks. And the problem is that these tools are very confident. They write in perfect legalese. They cite cases that do not exist. And if you are tired and you are under pressure and the language looks right, you might not check. Therefore, again a question was posed, is this an AI problem or a pendency problem? And a beautiful answer was given. Said, it is a system problem that AI has made visible. The pendency was always there. The temptation is to cut corners and always there. AI has just given that temptation a very convincing costume. This was the observation.
Thank you so much, sir. I think you summed up the entire conversation. I can't thank you enough for that. Really put things into perspective. Yes.
So, sir, in fact, the senior advocate designate under whom I trained, he would never let me use SEC online those days in early 2004s and all. He would say, research from the book, because for finding one point of law, you'll come across 10 more, which you will not need it now. But when you will need it, you don't know. So at the time of speed drafting, many times a matter would come to us, which we would be required to file very next day. So those things, verified notes, would come very handy. And I remember my senior making me sit in the court for the entire day, taking notes of all the cases and the citations being mentioned throughout the day and the ratio along with that. And I still have those notes.
Wow, impressive. Anyway, any questions from the audience we're happy to take? Wow, a lot of questions.
Yeah, first of all, thank you panel for this insightful discussion. And my question is, with the rapid advancement of AI and increasingly automation of legal framework, I just want to understand from you what potential steps should early career legal practitioners should take to future-proof their careers and remain indispensable in an increasingly AI-enabled legal environment. Thank you.
So, yeah, I think the same thing which I said, use AI, and it's for the freshers mainly, like law students and freshers. Use AI. Without AI, you can't survive. Like if you know how to use AI, if you're making use of AI, you will be valued more and you will have an edge over the other candidates for sure. That's the first thing. Second, while using AI, don't trust AI. Use it, but as Gaurav also said, you need to verify everything. So whether you verify do your research first and then go to AI for check, or you use AI, get a lead and then verify it, either way it's important. If you're not doing both steps, then it's going to give you results maybe 3 or 4 years down the line. So today, maybe as a fresher, as a first year student and associate and all, you are able to give a quick answer to a legal research or a quick draft whenever needed and all. But if you are, and same what Gaurav was saying, if you are actually not reading those 2000 extra cases, if for that one particular query, if you are not actually researching and seeing those 2000 irrelevant cases or notifications, you are losing on those 2000 notifications and things. So after 3 or 4 years, when you are senior associate and you are negotiating a contract or discussing something with your clients and all, you don't have actually that base of 2000, 4000 extra things which you have read. So there's a reason why advocacy is called a practice. You need to learn, you need to keep reading, and all these irrelevant or not so relevant things to a particular contract and all, something which shapes your knowledge and which will make you a better senior lawyer. So maybe with overuse of AI and all, you have an edge today, but if you want to continue in this profession and be a good lawyer at each and every stage, you need to keep learning, reading, verifying, use AI, but don't stop reading. That's the thing.
Just to add what exactly Priyesh said, make your base strong. Very simple questions. For example, if I'm interviewing a fresh graduate, my first question is, tell me one crime under the IPC or the BNS now which doesn't require an intention. Very simple question. But the basics also is not clear because the dependency on the tool is so much from a very young age. Make your base strong. And that is where your verification skills will enhance your professional output by the speed of AI tool. Make your base strong. And that can only happen when what Priyesh also said and other panelists said, be on the ground, do the job. There's no escape out of that. I had to let go somebody because over-dependence on the tool. So if I had to be dependent on the tool, I would have just spent 3,500 as a premium member of that rather than having somebody in the office doing the drafting work. Your essential skill set is to make your base strong. If that is not there, no AI tool will help.
Thank you. Next question.
Yeah, hi. So first of all, thank you for the discussion. It was really interesting. My one question, right, is like, what is the message for tech developers or tech companies like us or similar, like those who are wants to develop something for the lawyers, for the AI with lawyers, I should say?
I think talk to the lawyers.
Yeah,
It starts
obviously
from
that's
there,
what I'm
right?
trying to. That's what I'm trying to do that. But we spoke about the limitations, the responsibilities, or how to use the current tools. But if you see deeply, there are very few tools which has been developed as per the Indian documents predominantly. The legal systems are obviously that can be read by anybody, but the way the documents are written, let's say in a district court, than a high court, than a Supreme Court, the patterns are different. Same words might be used differently in a district court than a high court and a Supreme Court. So how the AI will frame out as an Indian context? That's why there are a lot of challenges or a lot of problems which are coming, and as Sir said, like the hallucination and things that which we were discussing about. So any guidelines for us in making it sound?
Trying to understand the lawyer's mind from an AI tool. So that is not possible. It's a very complex mind.
No free advice.
Yeah. No free advice. Come with a check, we'll tell you.
Sure. Point noted, sir.
Hi. So I did hear throughout the panel that we were about trust. We should not trust AI, but obviously use it. So I wanted to know, we have a lot of prominent AI tools in the market that we might be using currently, but there are also certain niche tools which are only focused towards the legal aspect. So what does the panel think? Should we depend upon the prominent tools or the niche tools that the legal industry has created?
Depends on your needs, right? See, because that may be a generic answer, but that is actually the truth, because what our industry requires is probably different, very different from what your industry requires, right? So I think start from there. Secondly, whatever tool it is that you already have, is that actually talking to the other tools which are existing within your ecosystem, that's another thing. Third thing is, from a practical and a use case scenario, talk to your competitors. I think you get the best of information from your competitors. Fourthly, industry bodies like CII, FICCI, whichever industry body that you all kind of collaborate with, that is like the powerhouse of information, right? So you can get a whole bunch of information, including these tools which are generally used in the market, and market intelligence definitely will help you to a great extent, right? Then finally, come to us, right? Because lawyers can tell you what suits and what doesn't suit, right? Especially if you're talking about tools for a legal department, then yes, I think an in-house counsel should be in a position, because he or she understands the business, also a little bit of technology, and of course the regulatory framework, right? So it's a combination of a whole bunch of things, but if you guys want to add.
No, I just want to add from a very, very practical and simple thing. Crux is same, what Smitha also said. If I am looking for a tool, it depends upon the kind of work for which I am looking for. Maybe for research or general thing and all, I'll rely on famous ones and all. But for contracts and specifics which are specific to my industry, my kind of work, I'll want something niche, some tool which still is under progress with some human intervention and all, so that they can customize it as per my requirement, not on day zero, but for some continuous transition period and all, because that customization to suit my requirements, my industry, my work with that human intervention till the tool is actually ready, rather than learning from market precedents and all, is very important. So if there's some tool like this which is niche and focuses on customization to meet personal needs, that will be something I think which my preference will be.
Just to add more to what Priyesh said, there is a difference between formatting and template. The biggest issue is the tools try to templatize the product. That's never the case, because each case is different and has to be approached from a different legal mindset. The issue with the tools is they give you a template which they try to apply on all such cases, which is definitely not the right ways of approaching a legal matter. So from a student perspective, try and appreciate that every fact, every rule would yield a different legal consequence. Every term that you use will have a different legal connotation. There is no synonyms in the field of law. Every term will have a legal consequence. So from that perspective, approach with a very curious, but at the same time protective mind, that you don't do such mistakes.
Actually, I hope we have answered your question. In the interest of time, I think we'll take the questions, offline. So thank you very much, and please connect with the panelists, outside. Thank you.
Thank you all the panelists. Let's have a huge round of applause, everyone, for all the panelists here.